You're watching The Legal Breakdown. Glenn, obviously a disastrous decision handed down by the Supreme Court as it relates to presidential immunity with Donald Trump. I want to talk about a few things today, including what happens to Trump's other prosecutions. But first, did the court basically just render itself irrelevant, neuter itself, compared to the executive branch? And the reason I ask that is because a president can now basically do anything that he wants and couch it in this idea that what he's doing is an official act. And so if the court system hands down an order, for example, why would a president even have to comply, given this newfound freedom to just do whatever he wants?
Yeah, it's a great question, Brian. Welcome to the American monarchy, because the Supreme Court may rue the day it handed this enormous swath of immunity against prosecution to all American presidents. Because, if there's one thing that a monarch or a dictator has absolutely no interest in, it is a Supreme Court. They love inferior courts, courts that are inferior to the executive branch, to the president, but not a Supreme Court. So I don't know why the Supreme Court would have just sort of cut off its nose to spite its face. But what it did was create these sort of three categories. And let me be crystal clear. They made them up out of whole cloth. I urge everybody to read all 120 pages, including the separate concurrence and the dissents. But what they did is they made up out of whole cloth. In fact, not only is there no supporting text in the Constitution, but as the dissent points out, this is contrary to the express language of the Constitution with respect to whether a president has absolute immunity against prosecution. And they came up with these three categories. They said, one, anything that is considered a core constitutional power, and I'll talk about what one example of that is in a minute. Anything that a president does that could be considered part of his core constitutional powers, he gets absolute immunity, no questions asked. The second category is for any official acts he performs, even if they kind of dwell on the edges, on the outer perimeter of his official presidential duties, those enjoy immunity too. They enjoy what they call presumptive immunity, which means they're very likely immune unless the prosecution can prove otherwise. And then the third category, they gave us a little something here. They said, well, for unofficial acts of a president, no immunity. Here's why this is so destructive to the rule of law. A core constitutional power is, for example, the pardon power. Only the president has the right to grant pardons and to commute sentences. So what this stands for is that if a president sells a pardon at $1 million a pop and pockets that $1 million, this Supreme Court opinion, this is not hyperbole, this is not a stretch, this Supreme Court opinion says it doesn't matter. You cannot look to the president's motivation. If he did something that constitutes an act within the core constitutional power of the presidency, he gets to do it. I mean, that is absurd, that is obscene, it's repugnant to the rule of law and to the notion that we are all, expected to abide by the rule of law, including a president. Doesn't matter. That's what the Supreme Court just made up out of whole cloth. The second category is this presumptive immunity for any official acts that might kind of be at the outer limits of his presidential duties and responsibilities. Now, they say the prosecutors can try to prove that they're not really official acts, and they send the case back to Judge Chutkan for some more hearings, including to try to figure out whether everything in the indictment, everything Donald Trump is alleged to have done, whether it's an official act or it's not an official act. That doesn't sound so bad, because I, for one, knowing Judge Tanya Chutkan from the days I used to try murder cases against her when she was a public defender and I was a homicide prosecutor in D.C., I have complete faith and confidence in her judgment, in her abilities, in her allegiance to the rule of law. So she'll get these things right when she has to start holding these hearings. But the judges went one step further. They said, you know what? When this gets sent back to Judge Chutkan for some hearings on what's an official act that Donald Trump is alleged to have done and what's not, we're going to tie not one, but both hands behind the prosecution's back in the following way. They say, and I'm quoting from the opinion now, testimony or private records of the president or his advisors probing the president's conduct on this official versus non-official acts may not be admitted as evidence at trial. Brian, what the hell does that mean?
So basically they're saying that any evidence that would prove something is outside the realm of immunity can't be actually admitted to prove that it's outside the realm of immunity.
Yeah, it doesn't sound like a workable paradigm, does it? Now, I guess evidence other than testimony and records from the president and his advisors can be admitted, but that's not the most directly relevant evidence to whether Donald Trump was doing an official act or not. So they literally tie both hands behind the prosecution's back. I mean, this is like a stampede toward totalitarianism by the Supreme Court. I, for one, don't understand it. More importantly, the dissenters, Justice Sotomayor, Justice Kagan, Justice Brown, they don't understand it. And, if you look at Justice Sotomayor's dissent, she says, quote, "With fear for our democracy, I dissent," close quote. She's calling it the way she sees it. So when I say this feels like a stampede toward totalitarianism, don't take my word for it. Take the word of a Supreme Court justice.
Glenn, this obviously raises the question, what happens to Donald Trump's other prosecutions that he's contending with? For example, in D.C., a lot of the evidence in D.C. and in the Florida case, for example, a lot of the evidence is Trump's own records, for example, or testimony from those closest to Donald Trump. If this is the precedent that's established now, how is any of that going to be admissible in this case? And what will happen to these cases that Trump is facing?
Brian, that's the great next question, and I am a little sick to my stomach right now because what the Supreme Court has done is like making up a new rule of evidence that wasn't even in existence. For example, when Donald Trump was being tried in New York for his 34 felony crimes, all of which he was convicted of, because when they come up with this new rule out of thin air saying testimony or records from the president or his advisors may not be admitted at trial, there were potentially some things admitted into trial that Donald Trump said or did when the prosecutors in New York were proving those 34 counts of falsifying business records to cover up hush money payments because Donald Trump wanted to steal the 2016 presidential election.
If he were to appeal that, based on this new Supreme Court ruling, how does that work in terms of does Donald Trump's New York conviction stand because this Supreme Court precedent wasn't established when the conviction was handed down? How does that work?
So I fear that it works in the following way. When the Supreme Court announces a new constitutional principle, we have this fiction that says the Constitution always meant that thing. We just didn't know it because the Supreme Court hadn't had occasion to rule on it. So it has what we call retroactive application, which means it could very well be that as part of Donald Trump's appeal, he says, well, look, the Constitution says a bunch of this evidence that the prosecution admitted against me in my New York case was not admissible, and the Supreme Court just said so. Unfortunately, they said so after his New York trial. So I can tell you, Brian, there will be robust litigation on this. And here is what I fear to my core. It's not necessarily going to be robust litigation that awaits Donald Trump's appeal after he's sentenced on July 11th. It may mean his July 11th sentencing gets pushed off. Again, it is, horror show after horror show after horror show. And similarly, down in Georgia, for example, if there's any good news, now that there is this new constitutional principle about what evidence can and can't be used against a president, former president, who's being criminally prosecuted. At least they can work it into litigation in advance of the Georgia trial, because we're treading justice water down in Georgia as well, while Donald Trump and some of his co-conspirators, his co-defendants, his criminal associates appeal Judge McAfee's ruling on whether District Attorney Willis, was properly allowed to continue to prosecute this case.
Not to add to the barrage of bad news that we already have, but I'm going to read you one more piece of Justice Clarence Thomas's concurring opinion that was in the immunity decision here. In this case, the Attorney General purported to appoint a private citizen as special counsel to prosecute a former president on behalf of the United States, but I am not sure that any office for the special counsel has been established by law as the Constitution requires. You'll remember that one of the justifications that Donald Trump put forward, a bogus on its face justification that he put forward to dismiss the Florida indictment, was this idea that Jack Smith, as a special counsel, doesn't have a basis to prosecute this case. We've used special counsels for well over 100 years in this country, dating back to the 1800s. But now Justice Clarence Thomas, has signaled in this Supreme Court ruling that he's actually opposed to that and aligns himself with this Trump attorney theory that in fact there is no basis to appoint special counsels to prosecute these cases. What are the implications going to be down in Florida?
First of all, Brian, that had nothing to do with this Supreme Court case.
Right.
Nothing. Was not an issue involved in this litigation. So what you just read was Clarence Thomas wearing his corruption, his compromise, and his conflict on his sleeve, announcing to Judge Cannon down in Florida, hey, I got you. Why don't you just go ahead and grant the motion to dismiss, because I am of the opinion, even though it wasn't part of this litigation, that Jack Smith wasn't lawfully appointed. You know, that, in my estimation, is the stuff of impeachment of a Supreme Court justice. And mind you, Brian, he is conflicted. He should not have participated in this opinion in any event. Neither Clarence Thomas nor Justice Alito should have taken part in the immunity case, because they are both conflicted out because, you know, of their wives' conduct and their conduct in support of the insurrection, and the federal law. Not that the Supreme Court justices seem to care about whether the federal law applies to them, but it does, and it says a Supreme Court justice whose impartiality might reasonably be questioned shall disqualify themselves. This adds insult to injury, to corruption, to conflict, to outright crime, and I think it's the stuff of impeachment.
Well, the sad part about that is that obviously impeachment relies on having enough members of the House and Senate who are also going to be willing to vote not only for impeachment, which requires a simple majority in the House, but 2/3 of the Senate to be able to actually convict. So as of right now, this is basically a fool's errand, considering we couldn't even get enough senators to vote to convict Donald Trump in the aftermath of the insurrection while that was still fresh. So the idea that, you know, these Supreme Court justices who are just enabling him without such overt action as Donald Trump took on January 6th in the aftermath of the insurrection suggests that we're not going to see any successful impeachment or conviction efforts anytime soon. So with that said,
Brian, let me just, I actually think this brings us to the silver lining. And yes, I have to close one eye and turn my head just so to find that silver lining today. But when you talk about how impeachment has to start in the House, this is yet another reason that the only ones who will save us are us, right? This has to continue to drive us to the polls, yes, in numbers too big to rig and too real to steal, because the remedy for what ails us is us, and us voting out, you know, voting the House into the hands of the Democrats, obviously making sure Donald Trump doesn't get anywhere near the Oval Office, so voting for President Biden. And then the other silver lining, because, yeah, we're heavy on the gloom and doom today because we have to accurately recount what the Supreme Court just did. But here's the other silver lining. The case is now going back to Judge Tanya Chutkan. And you know what she gets to do? She gets to begin holding hearings. And yes, you know, the prosecutors have had their hands tied behind their back, so it may not include all the evidence we would love to see, but she does get to hold evidentiary hearings. So even though it looks like we won't have a trial in the D.C. case for Donald Trump trying to overturn the results of the 2020 election, we will have public hearings, and there will be evidence, and there will be witnesses, and people will at least begin to see or get real-time reports coming out of the courtroom of just some of Donald Trump's crimes back on and around January 6th to try to unlawfully retain the power of the presidency. And let's hope that information continues to resonate with voters and prove Donald Trump's, you know, his complete disqualification from ever taking the reins of federal power again.
Well, look, in the absence of this trial in D.C., I think it's incumbent upon us to beat the drum that is his corruption, especially as it relates to this trial. So you just brought up the point that there will be these evidentiary hearings. I think that it's going to be especially important then for us to cover them as much as we can, you know, in the absence of what should be a trial happening right now if it weren't for the Supreme Court acting on Trump's behalf. So with that said, for those watching right now, if you want to help us in our efforts and make sure that we expose all of this stuff, put it on as big a stage as we possibly can, please make sure to subscribe as we continue to cover what happens in D.C. as well as Trump's other prosecutions right now. The links to both of our channels are right here on this screen. I'm Brian Taylor Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.